Roland, pleasure to talk to you today. I've been the mediator in over 200 bankruptcy clawback actions, preferences, fraudulent conveyances, and cases of that nature. Some of the larger bankruptcies in which I've handled mediations are most recently Sears. Other cases are Kodak, Delphi Automotive Systems, Greenwich Century Partners, which is I guess, a Madoff feeder fund, and all different industries and cases of all different sizes, from tens of thousands to, multi-million-dollar cases. And they're all interesting and they're all important to the parties. Let me start out by saying that I definitely recommend mediation, particularly for clawback cases. I find that the mediations generally reach settlement far more than half the cases. And even when you don't settle, you move the ball forward very often, and you can settle in the near or short term based upon the issues that bubble up during the mediation. I think that there are significant advantages in the process because the parties save money. They're able to bring to the forefront important issues earlier than they would have if they were on the trial discovery calendar. And if you can make a resolution and conserve expense, and hopefully it's fair, that's for the benefit of all. For starters, preparation, as with anything in life, is absolutely essential, and mediation is no exception. It's not really rocket science what I think you need to do. You've got to obviously read the papers of both sides. You've got to analyze important legal issues. In preferences, there's a lot of statistical analysis, but you also have to be familiar with the major cases and apply the facts of every case. And of course, the facts of every case are different, so you have to apply it to the law. And you have to do your own independent research, because it's possible that you may, as the mediator, may see an issue that's important that the parties haven't focused on, or one party hasn't focused on. So you want to be ready to discuss that issue with the parties. Often I will contact the parties in advance of the actual mediation day to vet issues, to let them know where I may see problems, so that we can have a more effective mediation. You have to be able to think on your feet and address problems during the mediation. You have to be creative, and you have to be ready to shift gears. Because what will often happen during the mediation is a whole new issue comes bubbling up. And you've got to be ready, and you got to know the law, and you got to be saying, now, wait a minute. What does that mean in terms of a defense? Or how does that impact the claim? And how do we deal with this? And be able to go back and forth between both parties fairly, so that you raise the issue and that both parties can form an informed analysis of what the case is worth, what the costs are, and hopefully lead them down the path to some sort of rational assessment of the strengths and weaknesses of their case, which is, of course, the road to settlement. Yeah, great question. Well, first thing you have to do is try to diffuse the tension somehow. That is a matter of psychology as much as law. And of course, it's different when you're doing an in-person mediation or a remote mediation. If it's in person, maybe you want to keep them apart, and you want to kind of lower the temperature even before you start. that is often, particularly in preferences, I like bringing the parties together at the beginning because these are heavily statistical cases and we have a common set of facts and it's just a matter of how you interpret them. However, when the parties really are locking heads, it may be better to keep them apart, or it may be better. For me, we had a situation, a case that you were involved with lately, where I actually made the presentation for both sides, rather than having the attorneys make the presentation, in the hopes that that might calm the waters a bit. Then I think the next step is, okay, you've started. You've got to focus on making incremental progress. You're not going to succeed right off the bat, not that you ever do, but you just want to focus on getting the parties to make small moves. You want to focus on commonality of issues. You want to perhaps do some decision tree analysis of, okay, we have this issue and we have that issue, and what's the likelihood of outcome? And you want to, so you want to do that. If in preference, often the defendant feels somewhat aggrieved because it's not an intent statute, you want to let them know that it's not necessarily that they did anything wrong. It's just a matter of application of the particular nuances of the preference law. Sometimes it's the plaintiff, and the plaintiff, for whatever reason, is not happy with a particular defendant. And you want to say, now, wait a minute, this isn't personal. Let's look at the facts of this case. Let's consider the expenses. You know, let's try to calmly break these issues down and make incremental progress. Be open, be optimistic, be creative. That's how I deal with that. Now, that all sounds great. It's not so easily done, but all you can do is your best. First, the process has to appear fair to both sides. They have to be comfortable in the setting. They have to feel that they're getting a fair shake from the mediator. That's number one. Second, in terms of the actual steps in the process, first I read the mediation statements. Then I go back to either counsel if I have questions or issues about the mediation statements, if there's any interesting legal issues or anything maybe that hasn't been considered, or maybe I see a weak spot in a particular argument. And I don't want to surprise anyone at mediation. I want to let them know if there's an issue that I think it would be helpful if they address. Because remember, it's not a trial, right? It's we're trying to get to a settlement. So you don't want to embarrass anybody. You don't want to favor one side. You want to give everybody an opportunity to be heard, bring out their best case. That's the best opportunity to settle the case. Then we have the actual mediation. And, before COVID, most mediations were in person. Now, obviously, they're remote. But in both instances, in preference, generally, I have a common joint meeting because we're dealing with the same statistics. And the question is, how do you analyze the statistics? If it's not a preference, we might meet in what I call executive session, and I bounce back and forth between both sides. But I get initial offers from both sides, discuss the law, and then I try to go back and forth. I raise legal issues, and I try to narrow the gap. And you can't do it all at once. You go session by session, talk to the business people and the lawyers, try to learn about the weaknesses and the strengths, try to treat those fairly, try to assess those with both sides, saying, I see strengths here, I see weaknesses there. Can you make a movement on this? If you move here, maybe the other side will move there. And just calmly, incrementally move the process toward a settlement. And then lo and behold, most of the time they're getting closer, and boom, you might have a settlement. The risk analysis is absolutely central to any successful mediation. What you're doing is you're assessing, you're trying, at least as the mediator, you're trying to get both sides to assess the likelihood of an outcome and the cost of getting to that outcome. And they're intertwined. What's involved in what is the legal cost? And perhaps there are expert witnesses involved. What is the total cost of bringing a case all the way through to trial? And what is your likelihood of success? And what would be a fair settlement? And what are the strengths and weaknesses of each side? And then you have to break it down. If there are multiple defenses, so what's the likelihood of outcome on each individualized defense? And practically speaking, what does this mean in dollars for both sides to go forward? So the law is important, but at the bottom line here is it's about money. And I tend to talk about the law more at the beginning of the mediation, but once we've gotten those issues laid out on the table, then I much prefer to just go back and forth to narrow differences in dollars. Now, it's not a perfect science. Sometimes a new issue comes up, but cost, risk, absolutely critical to a successful mediation. And a good mediator does not focus on the law alone. They focus on costs, uncertainty, risk. It all goes in the hopper. One of the most interesting aspects of mediation is you're dealing with real people. And you're dealing with people's, you're dealing with not only money, but you're dealing with emotions. And on the one hand, that's difficult, but on the other hand, that's what makes it interesting. And you're doing your best to bring them to the parties to a fair resolution. And sometimes things get, a little heated. So I've had, people stalk out. And sometimes the best thing to say to them is not to beg them to stay. Go ahead, go. Yeah, you might lose $600,000 if you don't stay here and try to work this thing out. But, I'm not going to beg you to stay. And that actually worked. They came back. I had somebody got very angry because I tend to be an optimist. So I'll often say, as we're narrowing the difference, well, the plaintiff said this, and then the defendant came back with that, and you were X apart, but now you're much, much closer. We're getting closer. And so that guy called me a used car salesman. So I got a kick out of that. I had another one station themselves at the door for about an hour while we had our conversation, about why they were, the case wasn't going to settle and we couldn't settle. And it's all part of it. It's that's what keeps it interesting.